It just reaffirms our right to be able to practice our medicines and our traditions in our own way, and to treat our people in the traditional way, without interference from outside governments that perpetuate that they have the right way to deal with First Nations and their health. This reaffirms our right to be able to treat our people the way we want.
Got to rush home soon because I've got to put some leeches onto a wound I have. And whose rights matter more? I mean, that is a question being asked now following a judge's decision, you know about this, to allow the parents of a young Aboriginal girl to refuse medical treatment for her leukemia in favour of traditional alternatives. Now, some legal experts are reminding Canadians that typically your charter right to freedom of religion does not trump a child's right to life, safety and healthy. Family lawyer Paul Cooper joins us. I understand there are sensitivities and sensibilities here. Of course I do. But there's such a lot of hogwash. And what that man just said, the idea that, I don't know, that Western medicine is taking Native kids away to hurt them. This poor child has leukemia. Now, not doing so badly at this point, but the alternative medicine, which is very expensive, by the way, there's absolutely no proof at all that it does anything positive for a person suffering from cancer.
That's right. I read that the doctor treating this child actually said that he knows of no case where a child has survived this without chemotherapy. There's controversy surrounding chemotherapy. It's invasive. It can be very painful. Sometimes it itself can cause people to deteriorate, even die from it.
There's no medical alternative, though. There's
no medical alternative. And in this case, this is a treatable form of cancer. It has a 95% success rate with chemotherapy. This case is not a family law case. This isn't something that would happen in a family court under the family rules or the family laws, the Child and Family Services Act that would govern. In all other cases, in situations of religion, a child's best interests determine whether children's aid or whether the child's going to be
Let me ask you this, and this is merely opinion, but if this child had not been Aboriginal, if the parents had not been Native, do you think the judge would have ruled in the same way?
No. If this child, and again, this is a constitutional decision. This decision, I'm not a constitutional lawyer, but what I can read into this opinion is that this decision is consistent with decisions surrounding Native fishing rights in terms of being tied to the original practices. It's a Section 35 of the Constitution decision. It would not happen in family court. In family court...
Okay, but before you go on, when it comes to fishing or property, it can be irritating. It can seem that the courts are not applying justice, they're applying politics. But in such a case as this, there is the right of a child to the best medical care possible. Now, if the parents came forward and said, as, I don't know, Jehovah's Witnesses or Christian Scientists or whatever, they objected to a certain form of medical treatment, the chances are they will be given very little tolerance in a court of law. In this case, now, if this, God forbid, this child, the leukemia develops again, what happens at that point? I want to play another clip first, because I'm sure the judge is an intelligent person, but some of the activists around this issue are not intelligent. They're hysterical. Can we see the clip, please, of the woman explaining Native history to us?
We looked after your ancestors when they arrived on our shores. The only reason our people start getting sick is because your ancestors start giving rot diseases with us and gave us blankets that were infested with smallpox. We were looking after our people, and we can still do that, and I'm glad that this court is reaffirming that.
Now, the reality is that there was ethnic cleansing of tribe to tribe, there was slavery, there was a most brutal, grotesque treatment. When people came here, whatever the rights and wrongs of that settlement, sometimes they were cared for, sometimes they were murdered slowly. Missionaries in Ontario who were Jesuits just trying to do good, the best thing. They weren't colonizing, murdered, tortured to death. So, and as for the blankets, they may have been infected, but it was before our knowledge of infection. It wasn't done on purpose. That's an urban myth. Things were done wrong. Of course, Native people suffered, but that was a child's history. That was a child's history. But now a real child could be in jeopardy because of our politics.
I agree. I think that statement is a distraction. I don't see how it's relevant at all to what's going on here.
You can be sure that infected, if you'll excuse the pun, that infected the decision. That sort of opinion has changed the culture of how we deal with Native people.
I disagree. I think the opinion was a constitutional decision. I'm not sure if that opinion infected. It might, in the sense that Aboriginal culture is, or the history of Aboriginal culture within Canada. I think that that press conference is a distraction. It's insulting. And what this decision could mean is where Children's Aid now can look, if a child breaks his leg and is never taken to the doctor and that leg becomes infected, teachers or social workers can refer to the matter to Children's Aid. They can investigate and ensure the child is cared for. In this situation, the limits to where the parents' rights to choose medical care, there's no limits. Now a child can get strep throat, and if that parent is Aboriginal and decides, I'm not going to have my child treated, he doesn't have to. If it becomes scarlet fever, so be it. It's part of the Aboriginal culture. I think that it's absurd. You mentioned the Jehovah's Witness case. In that case, the court explicitly balanced the proposed treatment versus the alternative treatment and determined that in that case, the proposed treatment was more likely to succeed. Therefore, the child's best interest was best served by forcing the treatment, in that case, a blood transfusion. In this case, if the same analysis were to be done, the court would determine there's a 95% survival rate with the treatment. We understand a 0 or a negligible survival rate without the treatment. And any other court, but for the Aboriginal issue, would have ordered that Children's Aid become involved and that treatment be administered.
Look, you know as well as I do that there are major problems within the Native community. Well, it's a disparate community, but many parts of it. Abuse being one of the challenges. There are lots of reasons for this, and it would be foolish and naive to think that we know all of the answers. But there is abuse. Are we allowed to deal with that? Is that being imperialistic and imposing our view? In Australia, there was within the Aboriginal community, again, abuse is a major issue. There was one point, about 4 years ago, when the Australian Army went into an area to deal with this, and it was successful. A lot of the kids were doing better, and the abusive parents were being denied any contact with them. There was a campaign by some Aboriginal activists to stop it. This was white imperialism. They seem to care more for making sure that we're in charge than with protecting their children. I'm deeply concerned at this decision.
That is precisely what's happened here. If you extend the logic of this decision, then the best interest of the child is where Children's Aid or any organization, there is an organization for Aboriginal people, it's Native Family and Child Service. If you extend the logic of this decision, then you're in a situation where the parents can choose anything for their children. We have a situation, children don't have the capacity to consent. Parents are given the ability, naturally, to make those decisions for them in their best interest. When they don't make those decisions in their best interest, we have legislation that provides the state can intervene. What this decision has done is said the state cannot intervene when the parents are Aboriginal. It's a constitutional decision. It's not something I would ever see in family court. I think it's sickening. And again, you can see a situation where children become ill, are neglected, and the agencies like Children's Aid may not ever intervene. This is potentially a precedent-setting case.
Appreciate it. Thank you very much indeed.
Thank you for having me.